UBC Real Estate Exam Prep. 26 practice questions from Chapter 7. Strata Properties, Condominiums and Cooperatives in British Columbia. Question 1. When a strata corporation grants an owner or tenant of a strata lot the permission to exclusively use common property as a short-term exclusive use. The correct answer is A. The permission requires approval by a 3/4 vote at a general meeting of the strata corporation, unless the short-term exclusive use is to endure for less than 6 months. Explanation. Under the Strata Property Act in British Columbia, a strata corporation can grant short-term exclusive use of common property to an owner or tenant without requiring a 3/4 vote, but only if the term is less than 6 months. For permissions longer than 6 months, a 3/4 vote at a general meeting is mandatory. This ensures proper consultation and agreement among strata lot owners for extended uses of common property. Explanation of options. B. Majority vote for minor changes. Incorrect. Significant changes or longer-term use need stricter approval, 3/4 vote. C. Limited common property designation. Incorrect. Exclusive use is temporary and does not change ownership or formal designation. D. Permission limited to 1 month. Incorrect. Permission can be granted for up to 6 months by the council, but longer requires a 3/4 vote.
Question 2. George bought 2 units in a 10-unit strata development. Within 1 week of the completion of this purchase, some of the owners of another strata unit, the Smithy family, were killed in an accident in the jacuzzi whirlpool. Mrs. Smithy was the sole survivor of this family. The pool is located on the common property in which George now owns an interest. Mrs. Smithy is suing the Strata Corporation and George is concerned about the extent of his liability for any damage award she may receive. Assuming that the Strata Corporation is found liable to Mrs. Smithy, which of the following statements correctly describes George's liability? Correct answer: George must pay his proportionate share of any judgment registered against the common property of the Strata Corporation. George, as an owner, is liable for his share of the judgment if the Strata Corporation is found liable. The share is based on his unit entitlement within the strata. Explanation of options. B. Liability insurance absolves George. Incorrect. While the Strata Property Act requires liability insurance, it may not fully cover the damages, and owners could still be responsible for shortfalls through their proportionate share. C. Contingency Reserve Fund covers judgment. Incorrect. The Contingency Reserve Fund is typically used for repairs and maintenance, not to pay legal judgments directly. D. Ownership time absolves liability. Incorrect. Liability is not tied to how long George has owned the units. It depends on his ownership status at the time of the judgment.
Question 3. Which of the following correctly describes an interest in land that is acquired by a buyer of a strata lot? Correct. Answer: C. A fee simple interest in the strata lot, and a fee simple interest in the common property as a tenant in common with the other strata lot owners. Fee simple plus tenant in common interest. A buyer gets 1. Fee simple ownership of their strata lot, 2. A proportionate fee simple interest in the common property, shared as tenants in common with other owners. Explanation of options. A. Fee simple interest only. Incorrect. The buyer acquires more than just a fee simple interest in the strata lot, they also acquire an interest in the common property. B. Joint tenancy with other owners. Incorrect. Ownership of the common property is not held as joint tenancy but as tenants in common. D. Share in the strata corporation. Incorrect. Ownership is not a shareholding in the strata corporation. It's a legal property interest in both the strata lot and the common property. Question 4. Which of the following statements comparing condominiums and cooperatives is false? A. Buyers of both condominiums and cooperatives acquire ownership of a fee simple interest in land. This statement is false because. Explanation. Condominium buyers acquire a fee simple interest in their unit and a shared interest in common property. Cooperative buyers do not own land or a fee simple interest. They purchase shares in a corporation, which grants them the right to occupy a unit. This fundamental difference in ownership structure makes the statement incorrect. Other options. B. Disclosure statement requirement. True. Disclosure statements may apply to both condominiums and cooperatives, especially in new developments. C. Ease of sale. True. Condominiums are generally easier to sell than cooperatives, as cooperative ownership often involves stricter approval processes and potential restrictions. D. Tenant protections under the Residential Tenancy Act. True. Tenants in buildings being converted to condominiums or cooperatives are protected by the Residential Tenancy Act in British Columbia. Question 5. Which of the following statements regarding strata properties is true? Correct answer. C. A bylaw that is passed by a strata corporation cannot be enforced against a strata lot owner unless or until it has been filed in the appropriate land title office. Explanation of options. A. Voting based on unit entitlement. False. Each strata lot typically gets one vote regardless of unit entitlement unless otherwise stated in the bylaws or required by the Strata Property Act. Restricting lease renewals to comply with bylaws. False. A strata corporation cannot restrict the renewal of existing leases to enforce compliance with leasing bylaws. Existing leases are typically grandfathered. C. Filing bylaws for enforceability. True. A bylaw passed by a strata corporation must be filed at the Land Title Office before it is enforceable against owners or tenants. D. Ownership of airspace above top floor lots. False. The airspace above strata lots is generally part of the common property not owned by individual lot owners. Its use is regulated by the strata corporation and not dependent on a special. Question 6. Under the Strata Property Act, strata corporations are obligated to do certain things. Which of the following is not a duty the strata corporation is obliged to carry out? Correct answer. C. The performance of work ordered by a competent public authority in respect of a strata lot. Explanation of options. A. Maintenance of property insurance on common property. True. Strata corporations are required to maintain property insurance for common property and assets. B. Creation of an operating fund. True. Strata corporations must establish an operating fund to cover common expenses like maintenance, utilities, and administration. C. Work ordered by public authority for a strata lot. False. The strata corporation is not responsible for work required for individual strata lots. Such work is the responsibility of the lot owner. D. Establishment of a contingency reserve fund. True. A contingency reserve fund is mandatory for unexpected or major expenses related to common property. Question 7. According to the Strata Property Act, which of the following statements is true? Correct answer. B. An estate in fee simple is created for each individual strata lot by the registration and approval of the Registrar of Land Titles of a strata plan. Breakdown of options. A. Unanimous vote for bylaw amendments. Incorrect. Only a 3-year vote is generally needed to amend bylaws, not a unanimous vote. B. Fee simple estate created by strata plan registration. Correct. Registration of a strata plan establishes an estate in fee simple for each strata lot. C. Condominium concept for residential use only. Incorrect. Strata developments can include residential, commercial, or mixed-use projects. D. Strata lots must be pre-sold before registration. Incorrect. There is no requirement to pre-sell strata lots before registering a strata plan in the Land Title Office. Question 8. Which of the following is not one of the obligations imposed on a strata corporation under the Strata Property Act? Answer. B. The obligation to maintain liability insurance of no less than $5,000 on the strata project is not correct because, while the Strata Property Act requires strata corporations to maintain liability insurance, the Act does not mandate a fixed minimum amount of $5,000. Instead, the amount of liability insurance is determined based on the potential risks and needs of the strata property, which may vary depending on the size and type of the development. The actual insurance coverage must be sufficient to protect against liabilities related to injuries or damages occurring on the common property, but is not explicitly set at $5,000 by law. Explanation of options. A. Obligation to repair common property. Correct. Strata corporations must maintain and repair the common property to ensure it remains in good condition. C. Establish a contingency reserve fund. Correct. The strata corporation is required to maintain a contingency reserve fund for major repairs or unexpected expenses. D. Fund for administrative expenses. Correct. Strata corporations must establish an operating fund to cover administrative and common expenses. Question 9. Common property in a strata title development is: Answer: D. Any property not designated as strata lots on a strata plan. Because common property refers to areas on the strata plan that are not designated as individual strata lots. These typically include shared spaces like hallways, roofs, parking areas, gardens, and recreational facilities. The common property is owned collectively by all the strata lot owners, and each owner's share of this property is proportional to their unit entitlement, a value reflecting the size and value of their strata lot. The Strata Corporation is responsible for maintaining and managing these areas for the benefit of all owners. Explanation of options. A. Owned equally by all members of the Strata Corporation. Incorrect. Ownership of common property is not divided equally, but is proportional to each owner's unit entitlement. B. Owned by the Strata Corporation. Incorrect. Common property is not owned by the Strata Corporation. It is owned collectively by all strata lot owners as tenants in common. C. Owned jointly by the Strata Corporation and the Strata Council. Incorrect. Neither the Strata Corporation nor the Council owns the common property. Question 10. Which of the following statements comparing cooperatives and condominiums is true? Answer: C. Buyers of condominiums will generally find it easier to finance their purchase than will buyers of cooperatives. Because financing for condominiums is generally easier because they involve fee simple ownership, which is more straightforward for lenders. In contrast, cooperatives involve share ownership, which can be more complex and harder to finance. Explanation of options. A. Both created by filing a plan in the Land Title Office. False. Condominiums are created by filing a strata plan in the Land Title Office, but cooperatives are created through the purchase of shares in a corporation, not by filing a land plan. B. Buyers acquire fee simple interest in the real property. False. Condominium buyers acquire a fee simple interest in their unit and a shared interest in common property, but cooperative buyers acquire shares in a corporation, not fee simple ownership of the land. D. Owners free to sell to whomever they wish. False. Condominium owners generally have the freedom to sell their units, while cooperative owners often need approval from the cooperative board before selling their shares. Question 11. The interest that is acquired by a buyer of a strata lot is, correct answer, D. A fee simple interest in the strata lot and a fee simple interest as a tenant in common with respect to the common property. Strata lot owners have a fee simple interest in their unit and a tenant in common interest in the common property, meaning they own a share of the common areas, but not as joint tenants. Explanation of options. A. A share in the Strata Corporation. False. Buyers acquire a fee simple interest in their strata lot, not a share in the Strata Corporation, although they do have a share in the corporation's decisions. B. A joint tenancy with all other strata owners. False. Strata lot owners do not hold joint tenancy for their strata lots. They own their individual lot in fee simple, not jointly with others. C. Fee simple interest in the strata lot and joint tenancy for common property. False. Strata lot owners hold a tenant in common interest, not a joint tenancy for common property. Question 12. Jane purchased a condominium on the understanding that pets were permitted by the bylaws of the Strata Corporation. Later, the corporation passed a bylaw prohibiting any owner from keeping any animal on their strata lot. When Carl subsequently purchased his lot, he was aware of this new bylaw. The Strata Council has ordered the removal of Jane's dog and Carl's cat from their lots. Which of the following statements is false? Answer: D is a false statement. Explanation. While the schedule of standard bylaws allows an owner one dog or one cat, this provision is not absolute. A strata corporation can override the standard bylaws by passing and registering a new bylaw prohibiting pets. If such a bylaw is properly passed and filed with the Land Title Office, it takes precedence over the standard bylaws. Thus, Carl and Jane cannot rely on the standard bylaws to keep their pets if the new bylaw is enforceable. Explanation of options. Carl must remove his cat. The bylaw is enforceable against him. True. Since Carl purchased his unit after the bylaw was passed, it is enforceable against him. B. Jane will not be subject to the new bylaw because she had a dog before the bylaw was passed. True. Jane's dog is likely grandfathered in under the Strata Property Act, meaning the bylaw does not apply retroactively to her situation. C. Pet restrictions are valid under the Strata Property Act. True. Strata corporations can pass bylaws restricting pets, and these are enforceable if filed with the Land Title Office. Question 13. Richard owns a 2,400 square foot unit in a strata complex. There are 19 other units, the square footage of which totals 37,600 square feet. The common property has an area of 12,600 square feet. The total common expenses for the year amount to $48,000. What is Richard's monthly share of the common expenses? To calculate Richard's monthly share of the common expenses, 1. Find Richard's unit entitlement as a percentage. Richard's unit size, 2,400 square feet. Total unit size in the strata complex, 2 to 400, 37,600 equals 40,000 square feet. Richard's share, 244,400, 40.06 or 6%. 2. Determine Richard's annual share of the common expenses. Total common expenses equals $48,000. Richard's share equals 48,000 times 6, 2,883. Convert to monthly expenses. Frac 2,080 12 equals 240. Correct answer D, $240. Question 14. Who owns the common property of a strata corporation? Correct answer C. Each individual strata lot owner owns a share of the common property of a strata corporation in the proportions set out in the Schedule of Unit Entitlement. Explanation. Strata lot owners collectively own the common property as tenants in common, with each owner's share based on their unit entitlement listed in the Schedule of Unit Entitlement. Explanation of options. A. The owner-developer as trustee for the strata lot owners. False. Once the strata corporation is formed, the developer no longer retains ownership of the common property. B. The strata corporation. False. The strata corporation does not own the common property. It manages it on behalf of the owners. D. None of the above. False. Option C accurately describes ownership of common property. Question 15. Which one of the following is not a remedy available to the owner of a strata lot who is dissatisfied with certain actions of the strata corporation? Answer. B. The owner may file a lien against the strata corporation is a false statement. Explanation. A lien is typically used by the strata corporation to recover unpaid strata fees from owners, not the other way around. An owner cannot file a lien against the strata corporation. Explanation of options. A. The owner may obtain a mandatory injunction against the strata corporation. True. An owner can apply for an injunction to compel the strata corporation to take or stop certain actions. C. The owner may have an arbitrator appointed. True. Owners can seek arbitration to resolve disputes with the strata corporation. D. The owner may apply to the Supreme Court of British Columbia for an order requiring the strata corporation to comply with the Strata Property Act. True. Owners can apply to the court for an order to ensure compliance with the Strata Property Act. Question 16. Which of the following is false with respect to strata lot ownership? The statement, "The sole purpose of creating a strata corporation is to limit the liability of the corporation members," is false because the primary purpose of a strata corporation is to manage and govern common property and enforce bylaws, not just limit liability. Liability protection is a secondary benefit. Explanation of options. B. The concept of ownership of part of a building is an ancient one, now recognized by provincial legislation. True. The concept of shared ownership in part of a building, such as in medieval times, has evolved and is now governed by provincial legislation. C. A strata development is a special way of subdividing land and buildings into parts for separate ownership with common features. True. Strata developments allow for the subdivision of land and buildings into units for individual ownership with shared common property. D. A strata corporation is permitted to pass a bylaw restricting the age of owners, tenants, and occupants to over the age of 55. True. Strata corporations are allowed to pass such bylaws under certain circumstances, often to create age-restricted communities. Question 17. A strata lot in British Columbia in an exclusively residential complex is owned by two persons as joint tenants. At every meeting of the strata corporation, correct answer, A, entitled to a total of 1 vote. Explanation. In British Columbia, when a strata lot is owned by two people as joint tenants, they are entitled to 1 vote as a unit, not 2 individual votes. This means that regardless of how many owners there are, The strata lot itself gets only one vote in strata meetings. Other options: B. Entitled to the number of votes calculated in proportion to their unit entitlement. False. Ownership as joint tenants gives only one vote per strata lot, not votes based on unit entitlement. C. Individually entitled to one vote each. False. Joint tenants share one vote, not individual votes. D. Entitled to one vote for special resolution, but individually entitled to one vote on all other matters. False. Joint tenants still only have one vote for all matters, including special resolutions. Question 18. Consider a building for which a strata plan was filed in August of 2011. In the event that the building is destroyed and the Strata Corporation passes a resolution not to rebuild, how will the proceeds of any insurance policy be distributed? Correct answer: B. According to the unit entitlement of the individual strata lot owners. Explanation: in the event of destruction and a decision not to rebuild, the insurance proceeds are distributed according to the unit entitlement of each owner. Unit entitlement is the share of the common property and the value assigned to each strata lot, typically reflected in the strata plan. Other options: A. Equally between all owners. False. The proceeds are not equally divided among all owners, they are distributed based on unit entitlement. C. According to the value each strata lot bears to the total value of all lots, values determined at the inception of the project. False. Insurance proceeds are based on unit entitlement, not the initial value of the lots. D. According to a conversion schedule based upon the most recent assessed values of the strata lots. False. The distribution is based on unit entitlement, not the assessed values or a conversion schedule. Question 19. A strata plan is, correct answer, A. Filed in the Land Title Office and designates which parts of a strata project are strata lots and which are common property. Explanation: a strata plan is a legal document filed in the Land Title Office that outlines the boundaries of individual strata lots and designates common property within a strata development. Other options: B. Used for both condominium and cooperative developments. False. A strata plan is specifically used for strata developments, not cooperatives. C. Required only when creating 5 or more strata lots. False. A strata plan is required for any number of strata lots, not just 5 or more. D. Essentially a package of restrictive covenants. False. A strata plan is not a package of covenants. It is a detailed legal plan showing the division of property. Question 20. The Strata Property Act does not permit a strata corporation to. Correct answer: C. Prohibit strata lot owners from selling their lots to non-residents of British Columbia. Explanation: the Strata Property Act does not permit strata corporations to restrict the sale of strata lots based on residency, such as prohibiting the sale to non-residents of British Columbia. Other options: A. Control, manage, and administer the common property. True. The Strata Corporation is responsible for managing the common property and assets for the benefit of all owners. B. Register a lien for unpaid strata fees. True. The Strata Corporation can register a lien against a strata lot for unpaid fees. D. Remove a strata lot owner's right to use recreational facilities on common property. True. The Strata Corporation can limit or suspend the use of facilities for certain reasons, such as non-payment of fees. Question 21. Which of the following is true? In a strata plan, the term unit entitlement refers to. Correct answer: D. The number used to calculate a strata owner's contribution to the common expenses of the strata corporation. Explanation: in a strata plan, unit entitlement refers to the number used to calculate an owner's contribution to the common expenses based on the proportionate value of their strata lot in relation to the entire development. Other options: the value of each condominium unit relative to other units. False. Unit entitlement is not about the market value of the units, it's a number used for calculating contributions. B. The share of the value upon demolition owned by each condominium unit owner. False. Unit entitlement is not about demolition value, it is related to contributions to expenses. C. The share of real property taxes payable by each condominium unit owner. False. Unit entitlement is not directly tied to real property taxes, though it can influence how taxes are allocated in a strata development. Question 22. Which of the following is not a statutory remedy available to an owner of a strata lot who is dissatisfied with certain actions or omissions of the strata corporation? Correct answer: D. A court may issue a judgment against the Strata Corporation but not against all owners. Explanation. This statement is not true because the Strata Corporation is a legal entity and judgments are typically issued against the corporation itself, not individual owners, unless the action involves personal liability of the owners. Other options. A. An owner may sue the Strata Corporation. True. Owners can take legal action against the Strata Corporation if they are dissatisfied with its actions or omissions. B. A court may order the appointment of an administrator in extreme cases. True. In extreme cases, the court may appoint an administrator to manage the Strata Corporation's affairs. C. An owner may apply for arbitration with the Strata Corporation. True. Owners have the option to apply for arbitration to resolve disputes with the Strata Corporation. Question 23. Which of the following best describes the Strata Corporation? Correct answer. A. The individual strata owners collectively, once the strata plan has been deposited at the Land Title Office. Explanation. The Strata Corporation is a legal entity formed when the strata plan is filed and deposited with the Land Title Office. It is made up of all the individual owners of the strata lots, and its purpose is to manage the common property and make decisions regarding the strata development. Other options. B. A body of 3 to 7 elected representatives from among the owners of the strata lots. False. This describes the Strata Council, which is a smaller group elected to manage the day-to-day affairs of the Strata Corporation. C. A corporation formed by a group of individuals who possess an undivided joint ownership interest in the land and/or buildings. False. This definition describes tenants in common, but the Strata Corporation is a distinct legal entity. D. A group of professional managers hired by a condominium project to handle the matters affecting the security and maintenance of the common property, facilities, and assets of the condominiums. False. This describes a property management company, not a strata corporation. Question 24. Which of the following statements regarding strata plans is true? Correct answer. B. A strata plan is filed in the Land Title Office and designates which parts of a strata project are strata lots and which are common property. Explanation. A strata plan is an official document filed in the Land Title Office that outlines the boundaries of individual strata lots and the common property in a strata development. It is the foundational document that divides the property into individual ownership and common areas. Other options. A. A strata plan is a plan contained in the disclosure statement filed with the superintendent that shows the developer's goals for the development. False. This refers to a disclosure statement and not the strata plan. The strata plan specifically outlines ownership and common areas. C. A strata plan is used for all condominiums or cooperative developments. False. A strata plan is used specifically for strata developments, including condominiums, but cooperatives operate differently and don't require a strata plan. D. A strata plan is only necessary when creating 5 or more strata lots. False. A strata plan is required for any strata development regardless of the number of strata lots. Question 25. Which of the following statements is false? Answer. D. Assuming the standard bylaws have not been amended, the Strata Council may pass rules with respect to the safety and cleanliness of individually owned strata lots. This is false statement. Explanation. The Strata Council generally cannot pass rules that control the safety and cleanliness of individually owned strata lots. This type of regulation falls under the purview of bylaws, not rules, unless it concerns common property or the external appearance of the lots. Explanation. A. In an entirely residential condominium complex, a bylaw must be amended by a three-year vote of the Strata Corporation. True. A queer vote is typically required to amend bylaws in a strata corporation, including for residential complexes. B. If a rule conflicts with a bylaw, the bylaw prevails. True. A bylaw takes precedence over a rule in case of any conflict. Rules are typically more flexible and cannot override the strata bylaws. C. A strata corporation is permitted to pass a bylaw restricting the owners, tenants, and occupants of a strata lot to individuals who have reached a specified age that is not less than 55 years. True. Strata corporations can pass bylaws that set age restrictions, such as the 55-plus rule, which is allowed under certain conditions. Question 26. With respect to bylaws in a strata development, which of the following statements is true? Correct answer. C. Bylaws provide for the control and management of the strata lots and common property. Explanation. Bylaws govern the use and management of both the strata lots and common property within a strata development, outlining the rights and responsibilities of owners and the strata corporation. Explanation. A. Bylaws are passed by special resolution of the Strata Council. False. Bylaws are typically passed by a special resolution of the strata corporation, not the council, which requires a through vote of the owners at a general meeting, not by the council. B. Bylaws may limit an owner's right to lease a strata lot if it is a commercial condominium complex. False. While bylaws can limit leasing rights, this can apply to both residential and commercial strata developments. However, this is subject to specific conditions and not automatically applicable to commercial complexes. D. Bylaws can be enforceable despite violating the Human Rights Code as long as they were unanimously passed by the members. False. Bylaws that violate the Human Rights Code are not enforceable, even if they were passed unanimously. Discriminatory bylaws are considered invalid under the Human Rights Code.